All right, it's time to look into what's trending in employment law. Lawyer, you're on the clock.
All right, so we've got a couple of topics I want to cover today real quickly. I'm not going to spend too much time going through all of the facts of the case, but this is a case that I mentioned before on this program. And yesterday, the city of St. Louis, through its legal counsel, submitted a 66-page brief to the United States Supreme Court, arguing that the Supreme Court should not disturb an Eighth Circuit ruling that a female police sergeant's lateral job transfer did not amount to gender bias. The city of St. Louis argued that changing the federal bias law standard would allow courts to micromanage the American workplaces. This case arose from a case that started in 2018, where the plaintiff in the case, her name is Jitanya Muldrow. She brought her case in Missouri State Court in August 2018. It was removed to federal court that December. She alleged that after the arrival of a new supervisor, she was removed from a prestigious intelligence division and placed in a different department where the work was more administrative. And she argued that happened to her because she was a woman. The Eighth Circuit, which is our court of appeals that covers Missouri on the federal level, the Eighth Circuit affirmed summary judgment in favor of St. Louis in April 2022, ruling that the plaintiff had not shown that the reassignment imposed a quote-unquote significant disadvantage since her pay and rate didn't change. So the Supreme Court agreed to take up the case in June after the request earlier this year. The Biden administration weighed in on whether lateral transfers can serve as the basis for the bias claim. In an August brief filed with the U.S. Supreme Court, the plaintiff in the case, Muldrow, argued that the Eighth Circuit added words to Title VII that fly in the face of lawmakers' intentions, and that the quote-unquote significant disadvantage standard should be scrapped. So this case is going to have far-reaching impact for employers across the country, because again, the Supreme Court is likely to decide what constitutes an adverse employment action in the discrimination context. Does it really need to have a change in the material terms and conditions of employment, such as employment itself, pay, supervision, benefits, or can it be something less, such as just a not as desirable job assignment, even though the material terms and conditions did not change? So again, a very, very significant case that the Supreme Court will be deciding. At some point, what will happen now is that the plaintiff in the case will get to file a reply brief to the Supreme Court, and then the Supreme Court, almost with guaranteed certainty, will set the case for oral argument, and the Supreme Court will then make its pronouncement on where the law stands on that issue. So that's the first one I have for you. The second one is not entirely unrelated. Nick, I'm going to put you on the spot here, see if you've been paying attention. I've mentioned before that Title VII, that covers discrimination in the workplace at the federal level, there's one specific word that's not covered in Title VII, or not used in Title VII. It appears nowhere in Title VII. I'm really putting you on the spot here, and I'm going to see if you know the answer to this question. What word never appears in Title VII of the Civil Rights Act of 1964?
I am going to go with it depends. No? It depends doesn't work?
Check your
How
chat.
about harassment?
Check your chat.
How about harassment,
which
I feel like I'm experiencing right now?
Yeah, sorry about that. Well, you are exactly right. The word harassment actually never appears in Title VII of the Civil Rights Act of 1964. The word discrimination appears in Title VII, but the word harassment does not. Harassment is a form of discrimination. And so the courts have said that Title VII did not need to use the word harassment because harassment in and of itself is a form of discrimination. And so not content with what the courts have said, the EEOC on October 2nd published its proposed guidance entitled Enforcement Guidance on Harassment in the Workplace. That guidance was initially proposed in 2017, but stalled during the change in political administrations. The new proposed guidance reflects changes to the law that have occurred since that time, though the EEOC is very quick to note that any final guidance document will, and I'm going to quote this, will, quote, not have the force and effect of law and are not meant to bind the public in any way, end quote. But again, if the EEOC is putting this out there as guidance, they're hoping to drive the agenda and get the courts to follow what is in this harassment guidance. So the first, I'm going to cover just some key provisions, and then we'll move forward with our guest. But the first provision is pregnancy and childbirth. So sex-based harassment includes harassment based on pregnancy, childbirth, lactation, etc., as well as a woman's reproductive decisions. So that's the first area that they're saying harassment can be in the form of pregnancy harassment, childbirth, lactation, etc. Sexual orientation and gender identity. In light of the Supreme Court's 2020 decision in Bostock versus Clayton County, Georgia, the guidance provides examples of discrimination based on sexual orientation and gender identity, such as intentional and repeated misgendering, as well as the denial of access to bathroom or other sex-segregated facility consistent with the individual's gender identity. This one, I can tell you, if they move forward with this, this will one day end up in front of the Supreme Court. There are cases right now, and the law seems to be holding out there that it would be an infringement on people's First Amendment rights for the government to tell people that you have to use a person's specific pronoun. So that's where the courts seem to be going right now. Two more points. First one is virtual harassment. With many employees working remotely, virtual harassment is actionable and includes comments made during a video meeting, racist imagery that is visible in an employee's workspace while the employee participates in a video meeting, or sexual comments made during a video meeting about a bed being near an employee in the video image. And these words come from this guidance. I did not make that up. So to me, these are things that are already included and covered within Title VII, but the EEOC nevertheless wants to make it very clear that such comments would be in violation of the law. And then finally, social media. Electronic communications such as texts or posts on social media can constitute harassment if they impact the workplace. The guidance further states that it is increasingly likely that the non-consensual distribution of real or computer-generated intimate images using social media can contribute to a hostile work environment if it impacts the workplace. So anybody who wants to provide feedback to the proposed guidance, we really don't have much time to do that. Comments are due to the EEOC by November 1, 2023. So stay tuned and we'll see if that guidance actually becomes effective. It's a little bit later this year. And then if the guidance does become effective, we'll wait for the EEOC to start enforcing the guidance and then seeing what happens if these cases end up in court. So that's what I've got today for Lawyer on the Clock.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link aimea.org/thisweekatwork or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.